My name is Paul Jacob. I'm the president of Citizens in Charge Foundation. We're one of the sponsoring organizations. We're a national group, so we work with some of these issues of people trying to strangle the democratic check on government all over the country. It's not just Colorado. But Colorado has been somewhat unique in that there have been so many attacks. In 1988, I believe it was, Meyer versus Graham was a case that went all the way to the Supreme Court, overturning Colorado's law on petitions that outlawed paying anybody to work on a petition effort. Then in 1996, American Constitutional Law Foundation versus Buckley, another case out of Colorado that went all the way to the Supreme Court, where again the Supreme Court overturned the restricted Colorado law. In 1996, you'll remember, they tried to create a 60% supermajority to pass an initiative in this state. It was trounced at the polls, but they were right back in 2008 trying to do the same thing again. And they outspent our side. It must have been 10 to 1 or more, and yet Referendum O was defeated. Well, they came back the next year and passed House Bill 1326, parts of which have already been enjoined by the federal court as unconstitutional violations of our rights, and part of which is still in effect, is what was causing John Caldera, Linda Gorman, and others potentially to fear that they could be bankrupted if they proposed an initiative. In last year's session, and again in this year's session, there was what was called this year SCR, Senate Concurrent Resolution 1, first thought on the legislature's minds, was to create that same supermajority, meaning that powerful forces could defeat a reform initiative simply by holding it down to 59.9% support. So there have been attack after attack after attack. The panel today, and I will introduce them as they speak, but these are folks who've been involved in this process and so have a lot of hands-on knowledge of what's going on. First, and they're going to speak very briefly, about 5 minutes, and then we'll try to leave as much time for questions as possible. First to speak is Shane Madsen. Shane is an election law expert and attorney with Jackson Kelly, and has been very much engaged in the lawsuit in state court against John Caldera and Linda Gorman. Shane?
Thank you very much. For a lawyer to only speak for 5 minutes is pretty tough, but I'd like to start out by reiterating what you've heard.
Mic's not on. You got to turn it off mute.
Gosh, I'm near a politician and he doesn't turn it on.
It's got an amber light.
Yeah, I think it's on mute right now. There you go.
1, 2, 3, 4.
Thank you very much. In any event, the attempts of the legislature to restrict the initiative powers in Colorado really accelerated in the 80s and 90s. But I believe that what happened in 2009 and this session in 2011 are really unparalleled attacks against the initiative process. Because what they did is create for the very first time almost a slap suit action by statute against individuals who had the courage to sign on to an initiative petition. So we'll just backtrack for a little bit. And in Colorado, each initiative starts out with a petition that is signed by 2 individual electors. It is not an issue committee, it is not a company, it's 2 individual electors who come forward with an idea, and it starts the process in Colorado. So what happened in 2009 with House Bill 1326 that was supported by virtually the entire leadership of the legislature, mostly Democrats at the time, is it created this slap suit against individual proponents of an initiative with the penalty of attorney's fees and costs if they had the nerve really in court to protect the initiative that they filed. I have been representing Mr. Caldera and Ms. Gorman with respect to a challenge that was filed under 1326 in Denver District Court. And I'll just go back and recreate the factual underpinnings of this lawsuit. John Caldera and Linda Gorman had the nerve or the wisdom to put their name on an initiative early in 2010 to attack the individual insurance requirement of Obamacare. They went through the process. They got their title set, which is the time in Colorado when you go forward and you're able to circulate your petitions. They were proceeding under the new rules that were adopted by House Bill 1326. Their title was set, I believe, on April 8th of 2010. A little bit before that, and we're graced in the audience with Lisa Sully, who was the attorney who filed the federal district court challenging the constitutionality of 1326. So you have a district court challenge going on. At the same time, you have a letter from the Attorney General's office representing the Secretary of State saying, well, in light of the fact that there is a recent 10th Circuit decision about the residency of circulators, we're going to tell you, Mr. Caldera and Ms. Gorman, that we're not going to enforce that law against you. So in other words, your circulators do not need to be Colorado residents. Well, that is swell. We go forward. The district court also enjoins preliminarily the statutory requirement of 1326 that initiative circulators cannot be paid by the signature. So Ms. Caldera and Mr. Gorman and Ms. Gorman go forward. They start the petition circulation. It includes circulators from out of state, which the Secretary of State and the Attorney General's office says is well and okay, and it includes residents of the state of Colorado. There was significant confusion at that time about what is required on the affidavit that a circulator needs to sign once they're turning in their signatures. Because notwithstanding the letter that was issued by the prior Secretary of State on April 8th that says we're not going to enforce it, the form, and you must follow the form that the Secretary of State adopts. The form sort of indicates you need to be a Colorado resident. So we have a situation where individual circulators are calling the Secretary of State saying, what gives? Circulating companies are saying, what do we do? We're not talking about people acting in bad faith. We're talking about individuals who are trying to comply with what was somewhat of a confusing state law situation. So against all of that backdrop, we have Mr. Caldera and Ms. Gorman turning in their petition at the requisite time in August. The Secretary of State says, you've got a number of signatures, we're going to certify you for the ballot. So what happens then is what happens to individual proponents under 1326, exacerbated by what the legislature did in 2011. Within 30 days of turning in their signatures, the Secretary of State saying, you've got to go on ballot. They, of course, get sued. Now, under Colorado law right now, if you're a political opponent as opposed to a proponent, you file it under an individual's name, and you have no idea who the group is that's really funding that lawsuit. So Ms. Gorman and Mr. Caldera get sued by a person by the name of Johnson. We still, to this day, have no idea who was funding that lawsuit. And what they say is, no claim against Mr. Caldera and Ms. Gorman, by the way. The claim is against the Secretary of State. And they say there wasn't enough signatures because those dishonest circulators used the wrong address. And what was the wrong address? Well, they decided it could have gone either way because legally they could have made either argument. But they said those dishonest circulators from out of state had the nerve to put down the residence or the address where they were living while they were circulating the petitions in Colorado instead of their out-of-state address. For those who were out of state and turned in those affidavits, they had to cross out the lines and kind of jimmy around with the affidavit, which makes most people kind of nervous to change the lines in an affidavit. But in any event, the lawsuit was based on the fact that these lying, horrible circulators who were being fraudulent under the system had turned in the wrong list. So Mr. Caldera individually, Ms. Borman individually gets sued. Not their issue committee, not Independence Institute, but these two individuals. So what happens basically is a flurry of paper and an awful lot of money. And I just brought for your visual pleasure, this is volume 1 of the pleadings file. Ultimately, we were able to get Mr. Caldera and Ms. Borman dismissed from the lawsuit. But what we were aware of in the very beginning is the plan was to file a lawsuit, not make a claim against Caldera or Borman for participating in fraud, but to basically bankrupt them by scheduling 54 depositions of the supposed dishonest, lying circulators. Now, for those of you who have not been part of litigation, 54 depositions is an awful lot of money, and it's an awful lot of attorney time. You have to plan, you have to prep your witnesses, you have to do the legal research for each witness. Fortunately, we were able to get them dismissed from the lawsuit, but all of you can do the calculations, even at the most inexpensive of lawyers, which frankly we are not, but we're not the most expensive of lawyers. You have to figure at least 10 hours per individual opponent. Their intention was to basically bankrupt the process. They backed off at some point in time, I believe, because of the good work of Lisa Solly and others on the panel here who were willing to sign on to an amicus brief, where the judge finally had to realize that what was going on here is an unparalleled attack on First Amendment rights. But these things are really dangerous. This kind of attack that creates individual liability is not one to be taken lightly. So what happens in 2011? Well, the folks who sued Caldera and Gorman weren't satisfied with the lawsuit they were able to file when petitions were certified for the ballot. So they get the legislature to pass a second law, which also authorized individual lawsuits. But this time it's a little earlier in the system. It's before the signatures are even counted, before you even know if you've got a viable option for the ballot or not. The minute you turn in your signatures, they've got a new name for these designated representatives, which is code for the proponents. That these folks have to turn in a report. And if that report has any material mistake of fact, then this individual lawsuit starts all over again. And the gotcha in the 2011 legislation, which by the way has not been signed by the governor, is this report has to detail every dime that's been spent, not just by the proponents, but anybody who might be supporting the issue. It has to detail every dime that was supporting an issue that these designated representatives may know nothing about. You guys kind of know how these big initiatives work. You've got several groups that are supporting them or opposing them. They may not coordinate with each other. So these designated representatives may have no ability whatsoever to turn in a truthful report. But if their report is deemed to be in error, then this other lawsuit starts earlier in the process. So my only purpose in coming tonight is to tell you this is a lawyer's dream. We are pleased as punch about the whole thing. Not really. It is an attack on First Amendment rights. Mr. Caldera and Ms. Gorman have paid dearly for that. They are dismissed from this lawsuit, but the lawsuit is still going on. The opponents, which we believe are the labor unions, but we can't prove, are still proceeding with the Secretary of State's office. And I imagine those 54 depositions are going to be taken and paid for by you and I as taxpayers. So that's where we are.
I should note that I know Shane's going to have to leave early, so if she's leaving, it's not because of anything anybody said. Thank you very, very much. Next, we get to hear from Colorado Senator Kevin Lundberg, who represents District 15 and has been one of the loudest voices in the legislature in favor of protecting petitioners' rights.
Thank you very much. I appreciate being part of this. This is a very important issue which seems so academic at times, but it has such an effect on every citizen and indeed our rights, starting with that very first right, not just speech, but petition the government, etc. Anyway, let me be kind of brief here. A couple of things. One, just a little background. I've spent 9 years, I'm in my 9th year, 9 sessions down in the legislature, and you'd think I'd be sucked into the system by now. But I see every year some attempt to pull back, to limit, to restrict, to get rid of the citizens' initiative process. And I see it as a very appropriate safety valve, because under the gold dome, we don't get it right every time. I know that sounds shocking, but it is very necessary that we be held accountable by the people, not only through our elections, but through the ballot process, but through the initiative process. Also, back in 2006, I was frustrated with what the legislature did that year as well, and launched my own initiative effort, and discovered for a citizen initiative, if you don't have the money, it's a very, very high bar, even in Colorado. I had 1,000 people just circulating petitions across the state, and we fell short. Now, we did have only a couple of months to collect our signatures in, but it's a daunting task. And we had to go through some of the legal issues as well. We were challenged on our title, and the Supreme Court had to ultimately sort that out, and we proceeded. But I know what it's like to be one of those 2 people who started the initiative, and how you really are on the line as a citizen. Finally, I'd just like to make a few comments about this latest lawsuit that was announced to be filed against Tabor. Tabor, of course, came through the initiative process, and what they're really challenging is the authority of the people to make decisions on taxes and limitations of spending, which is what the Taxpayers Bill of Rights does. And just a very, very brief snapshot on a couple of elements. I was actually have put together an op-ed piece on this, and as I did my research, I discovered a few interesting things. One, in the state of Colorado, the initiative process is in the Constitution as the very first part of Article 2, which deals with the legislature. So our Constitution is very clear. The initiative process is the beginning of legislative concerns, if you will. And in there it states, it starts with the acknowledgement, all political power is vested in and derived from the people. Additionally, the people are recognized as having the, quote, sole and exclusive right to alter and abolish their constitution and form of government. The only limitation there is that it not be in conflict with the U.S. Constitution. Of course, what they're going after with this lawsuit is the contention that in, let's see, what is it, Article 4, Section 4, I believe, of the U.S. Constitution, every state is guaranteed a, quote, Republican form of government. Their contention being that Republican form of government means representative form of government. Now, let's just take that argument on its face value at first and say that that's what Republican form of government means. How could that be the, how do I put it? It's inconceivable to me that could be construed as to say, and the people don't count and cannot play a role in that arena. Actually, if you look at the Declaration of Independence, it states that the intent is to stay as far away from the autocratic rule of the king or any other elite ruling power and to put the power back into the hands of the people from whom that political power is derived in the first place. How you can interpret the Constitution as doing anything but trying to protect the people from autocratic rule and to empower the people is unbelievable. But that is their main thrust as it's been presented. And I say that because every press release I've seen and news report says the lawsuit is expected. So I don't believe it's actually been filed. Now maybe somebody can correct me on that. But if their point is that that is the guarantee clause in the U.S. Constitution, is just totally bizarre. It shows you how far some of the powers that be out there want to go to muzzle the people. With the Taxpayers' Bill of Rights in particular, it is a restraint that has had some effect. I think it's a good effect, but nonetheless it is an effect. And they don't like that at all, and they're willing to sacrifice the whole initiative concept over this one initiative, or now amendment to our state constitution. And I also point out one other point. In our U.S. Constitution, it begins with those words, "we the people." How much further must we read to truly understand where the initiative process belongs in our form of government? Now, I'll certainly grant that the U.S. Constitution is not a place for the initiative process, because that is a document that really limits federal government and doesn't have all the components of state governments. If you look at the 9th Amendment and the 10th Amendment, you really see that that's reserved for the states. That's the appropriate venue for the people to exercise their grassroots authority and to really make a difference. And if you don't like what your state did, move to another state. We've got 49 others to pick from. The whole sense of this lawsuit, to me, points out just how intense some people are in not just limiting, but literally getting rid of the initiative process. And I assure you, I will continue to do all I can down at the legislature to hold back and maybe even give us a little more throwaway down there.
Let me next introduce Elena Nunez. She's the Executive Director of Common Cause and has been a fantastic force in protecting initiative rights in the legislature. And I should note that last year, because of her efforts in protecting the process, Citizens in Charge Foundation, each month we give a Lilburn Award. John Lilburn was a 16th century British pamphleteer who really started the first petitioning called that and understood that way. And each month we awarded to whoever in the country has done the most to protect initiative rights. And last year, about this time, that person was Elena Nunez.
Thank you. So for those of you who aren't familiar with Common Cause, we're a national, nonpartisan, nonprofit organization that works for open, honest, and accountable government and to increase people's ability to participate in the political process. So as John Caldera mentioned in his opening, we often land on different sides of the issue from the Independence Institute, but one where we do see very closely eye to eye is the initiative process, because we think it's important to give people an opportunity to be heard in their government. We've also, in our 40-year history here in Colorado, used it quite a bit. In our view, the initiative process is important because it allows people to address issues when the legislature won't, either because they have a conflict of interest or lack political will. So for a lot of the work that we do, which is about opening up the process, not surprisingly, we don't see a lot of support for that down at the Capitol. So our first campaign here in Colorado back in 1972 was actually the Sunshine Clause, which is the idea that if there's a public business being done, it should be done in the public eye. And that if you're going to lobby at the state capitol, you should know who's hiring you. Really basic things, but at that time, it was viewed as a tremendous attack on the establishment from the Capitol. So not surprisingly, we went the initiative route. And since then, we've used it again for everything from campaign finance and ethics reform to the Gavel Amendment, which was one in the 1980s that, again, saw tremendous outcry from the establishment because it went after the practice of binding caucuses, where your legislative leadership told you how you were going to vote, and you had no opportunity to dissent. What leadership said went. The other thing that was going on was that if a committee chair didn't want a bill to be heard, they could simply pocket veto it, and the bill would never get a hearing and would never have its day in the legislature. So we went about filing a constitutional amendment to say, okay, we want to have the right to have a public hearing on every piece of legislation. And we think that legislators should be able to vote their consciences and not be told by the leadership how they should vote. Again, as you might imagine, tremendous outcry. Leadership at the time filed lawsuits to block the implementation of gavel, and it was a tremendous fight that eventually did end with its implementation, but not after tremendous outcry. And what we've seen here in Colorado is that it's only because we have the initiative process that we have open government, that we have campaign finance reform, that we have ethics regulations in place. That absent the initiative process, we would never see those issues come forward. And indeed, if you look at our neighboring states like New Mexico, which don't have the initiative process, you see places that don't have term limits. You see meaningful disclosure tends not to happen, especially at the state level. There's a real roadblock to reform that happens. So for us, it's been an incredibly important tool to really forward the debate on open government, because when it comes to legislators and the work that they're doing, they don't really respond well to criticism or the idea that there's a different way that the process should be run. So for us, it's been incredibly important. I wanted to spend just a couple of minutes, though, talking about some of the attacks that we have seen at the Capitol, though, because some of the other speakers have mentioned them. But the tenor of the attacks has really intensified over the last couple of years. And I think Senator Lundberg really hit the nail on the head when he said it was about Tabor. Because what we're seeing here is that the initiative process debate has become a proxy for the debate about Tabor. Now, full disclosure, Common Cause opposed Tabor. We think that it needs reform. We'd like to see it repealed. We think we need greater investment in our state. But that's not the debate we're having. Instead, the debate that we have at the Capitol is about the initiative process and the idea that the people aren't suited to make those decisions, and that we can't have a public policy debate about taxes or expenditures and actually have that debate. So instead we just say, oh, the initiative process, people don't know what they're doing. And that becomes the kind of limiting factor in the conversation up there. And the result has been a really dramatic effort to limit the initiative process, in part to those who can afford to play under much more expensive and difficult rules. So two of the measures, and again, this was brought up a little bit in the introduction, but I want to just talk a little bit more about them, have to do with how constitutional amendments get passed in Colorado. Because again, there's the sense that it's just too easy to amend the Constitution. And for anyone in this room who's worked on a constitutional amendment, it's kind of laughable that you can get 86,000 signatures and then persuade a majority of the state to vote in support of something, and that you just sort of do that loosey-goosey without much effort or intention. But that's the popular belief at the Capitol, that initiatives are run by folks who aren't really thinking clearly about the public policy choices that they want to put forward, and that it's done quite easily, that once you put something on the ballot, it's given that it will pass and it will go into our Constitution. That hasn't been my experience. In my experience, it takes a lot of hard work to get the signatures and to actually make the case to the voters. But that's the narrative that dominates the legislature. So when they look back at Tabor and they look back at campaign finance reform, ethics reform, pretty much every measure that Common Cause has advanced in the last 40 years, they say, oh, well, if only we made it so it took more votes. If you took 60% of the populace, if they had to approve 60% of the people who vote on a particular issue, if they had to approve it, that would keep things out of the Constitution. And we wouldn't have to worry about the people mucking with the laws. We could just take care of business the way we need to. So that's one piece that they want to see. And this is really kind of the bread and butter of all of these proposals, is how do we stop future things from ending up in the Constitution? And it's actually been a pretty sophisticated strategy over the last several years as they look for ways to keep the bad stuff out, bad, quote unquote, while still giving themselves the room to repeal Tabor. So you see increasingly sophisticated drafting where it says, okay, well, if you want to put something in, you take 60%, but it's a simple majority to take anything out of the Constitution. Or is it an amendment to the Constitution, or is it a full-out repeal? And there have been various permutations over the last several years, but it's all, at the core, this debate about Tabor. What do we do about Tabor, and how do we make sure it doesn't happen again? And then the other piece of it is how do we make it more difficult through the signature gathering process? Again, anyone who's put anything on the ballot and had to gather 100,000 signatures throughout the state knows it's not easy, but there's this perception you just write that check which, you know, everyone's just got $500,000 lying around to write that check, and you've got the signatures and you're done. And it's just too easy. So they want to make it more difficult by saying you have to go into every congressional district, or you have to go into every state senate district. And if we do that, we'll just have a better process because you'll have to talk to more voters. But what they're really saying is you need to have more money because you need to be able to run petition offices in 7 districts instead of having 1 petition office or 2 petition offices. And you need to have an infrastructure in place so that you can check all your signatures and make sure that they're coming from everywhere that they're supposed to. And what's the result? It's not that people won't use the initiative process. It's that only people who can afford to spend twice as much on the signature gathering drive will use the petition process. So for folks who have the money to amend the Constitution, go ahead. For grassroots groups like Common Cause, like many of you in this room, not so much. And that's the attacks that we're seeing, this ongoing effort to say, keep your hands off the Constitution. Maybe you can amend statutes, that would be okay, and we'll throw you a bone, we'll say that we won't amend them for a couple of years, that way you'll feel better. But that's all we're going to do. And it's becoming increasingly popular. I think, you know, we really dodged a bullet this year that it didn't go to the ballot. There were enough co-sponsors practically in each chamber to put it on the ballot. The momentum is growing, and now we're seeing business interests, labor interests, you know, some of the, you know, those who fund ballot issue campaigns are saying that they don't want to put money into ballot measures anymore. They want to take the process off the table. Because it's, again, as the previous speakers have said, it's about consolidating power, and it's a lot easier to persuade a majority in 2 chambers than a majority of the voting public that they should support your issue. So I really appreciate the opportunity to be here today and talk about this issue. It is a big fight, and I think it's just going to continue. So the more that we can do to really escalate the dialogue about how important this process is as a safety valve on both the left and the right, I think will be crucial to maintaining the process.
Dane?
Thank you very much, Paul. And for the almanac, for those of you who have it, it's a great doorstop. Many of you have used that. So I'm going to market it on Amazon as that versus the content. But no, I have been involved in the initiative process for, you know, over 20 years. I'm from Alabama, and being from Alabama, I had never even heard of the initiative process. But this guy by the name of Paul Jacob one day decided to hire this little boy from Alabama, and because of Paul, in full disclosure, I know about the initiative process. But in working with U.S. term limits, putting initiatives on the ballot for term limits, you know, I realized that there wasn't an organization that really studied the process and provided comprehensive information about the process. So after leaving U.S. term limits, I started the Initiative and Referendum Institute, which is now housed at the University of Southern California. And several people in this room have been part of the Institute. Bob Nadelson has helped out in many ways. Vince Polehill has. So there's a lot of friendly faces in this crowd over the years that I've worked with. But now I'm working with the Humane Society of the United States. You know, a lot of people think, well, HSUS, do you guys do ballot measures? Well, actually, outside of U.S. term limits, HSUS is the second most prolific user of the initiative process. Now, Wayne Pacelli, who's the CEO of HSUS, likes to say that HSUS is the most prolific user, but I have to correct him all the time and say it's actually the term limit movement. But you know, we've been involved in over, the Humane Society has been involved in over 42 statewide ballot measures on a wide range of issues. We have a 72% win rate. And as an organization, you know, what we typically try to do is we try to use the statutory initiative process because we believe that a lot of things, you know, if you're changing gestation crate sizes for pigs or hens, it doesn't belong to the state constitution. That's a statutory issue. But one thing that we have found across the country is that even though there is strong support for these issues, whether it's puppy mills or whatever it may be, you know, the legislature, for whatever reason, just chooses not to deal with these issues, and that we as an organization go to the initiative process as a last resort. But as you can imagine, with our successes, what we're seeing is a backlash against us as an organization. As those of you who know, if you can't kill the message, you kill the messenger. And if you can't kill the messenger, you kill the process in which the messenger uses, and that's the initiative process. And that's what we're faced with. Every year we're finding, like even here in Colorado, in Massachusetts, and Washington, you know, every year we are now spending hundreds of thousands of dollars trying to defend statutory initiatives that we passed. And right, wrong, or indifferently, you know, the voters spoke on this. And it's interesting to me, I talk to lawmakers, and all lawmakers aren't evil and bad, but not all of them. But it's interesting that, they think that somehow when they're elected that the citizens have given their sovereign rights up. That, hey, we're giving you our sovereign rights, and no longer do we have any say-so. And I also find it interesting as a side point that, I meet lawmakers all the time that says, oh, the voters are stupid. Like in Missouri, we just passed a public mill initiative. And the voters said, the legislature says, well, the voters were incompetent. They had no idea what they were voting on. But when they voted on me, they were very smart when they made that decision. I just don't understand that logic. And the reality is, lawmakers, not all of them, but the majority of them seem to think that, okay, they're elected, they're the only ones who should be making the laws, and the citizens should not be messing with them using the initiative process. But what we've done as an organization is, we're seeing in states that where lawmakers are trying to say, okay, well, the initiative process cannot be used for wildlife measures. Or if you're doing a specific issue on agriculture or wildlife, you must get a supermajority before it can pass. Or they're just outright trying to take away the initiative process. What's troubling to me as a supporter of the initiative process, not only is the legislature trying to mess with the process, they're trying to focus it on a certain specific industry and sect that has used the process because they just don't like it. And so we as an organization are starting to fight back. In Missouri, even though our puppy mill measure, let me give you a little background. We passed this anti-puppy mill initiative in Missouri that would bring basically certain standards to puppy mills. And actually, just so you know, 30% of all puppies in this country come from the state of Missouri. Over 1 million puppies each year that are sold in your stores come from the state of Missouri. But anyway, so we passed this property. It passed with 51.6% of the vote. But literally within days of the passing, the legislature says, we're going to repeal it, we're going to repeal it, we're going to repeal it. And so we did this dance where we fought the legislature. They passed a repeal, and they were trying to put an emergency clause on it, so we couldn't do a referendum. Here in Colorado, you have the safety clause. So we kept fighting. And, eventually we lost, and the legislature won. But we've decided as an organization to work jointly with groups like Citizens in Charge, Americans for Tax Reform, National Taxpayers Union, reaching out to the labor unions and organizations on the progressive side to push what we call the Your Vote Counts Amendment. That would require a 3/4 vote of both houses of the legislature before they could overturn a citizen-passed initiative. And also, or they have the option of putting it back on the ballot. And as an organization, it's critical to us because, if we're spending hundreds of thousands of dollars literally every year across the country to protect our lands, it makes sense for us to invest in that mechanism to keep the lawmakers from messing with our victories. But we also see the process. We want to see it expanded. We would love, as an organization, to see the statutory initiative process come to Florida and in Colorado. Here, we would love to support efforts to make the process more open and usable. And so the Humane Society, we're an 11 million member organization. We're very fortunate to have a lot of, the ability to fight some of these issues. But you'll see over the coming months and coming years that we as an organization are going to be taking a very active role in trying to protect the initiative process, expand the initiative process, not only for us, because we believe it should be used for all people, all organizations, across all political persuasions. And I'm happy to be here. I'm happy to work with Citizens in Charge. And if you have any questions later on, I'm more than happy to take them.
Our next speaker is Thad Texa. Thad is the Senior Instructor Emeritus at the University of Colorado Boulder. Has been very active in coalition efforts to battle in the legislature against some of these changes. Thad?
First of all, I would just like to say that I don't understand why as soon as people find out you taught at CU Boulder, they always put you on the left of the band. It seems to be the case. I also, having been born before microphones, have a pre-microphone voice, so if anybody can't hear me, let me know.
I'm recording your voice. I need you to.
Can you hear?
No, I'm recording you. So
oh, you're recording?
Even though they can
okay,
hear you.
well then I'll try and speak more softly. And finally, as a prefatory remark, I'd just like to say that Speaker of the House, who is so opposed to initiatives, got his first political experience as a student in my internship course. I say that for those of you who believe that education is the solution to all problems. I knew it was time to retire when my students started to be term limited out of the legislature. That when they would come to me and say, I took your class because my mother had you as a professor and she said you were really good. I thank you as a class. But given that, what I'd like to talk to you about today very briefly is a reason for the initiative process that's at the state level that's often not discussed. And it comes from the fact that when people attack the initiative process, they often use the analogy to the federal constitution, to the national constitution. I remember Andrew Romanoff, former speaker in the House of Colorado, pulling out the U.S. Constitution and saying, why can't our state constitution be a short, simple, clear document like this one, right? And it's these initiatives that are cluttering it up, ignoring, of course, as we've heard, that 2/3 of the changes come from the legislature, also ignoring, by the way, the fact that one of the reasons state constitutions is so long is because the U.S. Constitution is so short. And so, for example, major sections in the Colorado Constitution deal with education and local government, which this Constitution doesn't deal with. Of course, they also presume that this is a simple, clear document, ignoring the over 200 volumes of Supreme Court cases trying to interpret its ambiguous language. But even beyond that, it's premised on the notion that Constitutions should be a one-size-fits-all document. I mean, for example, the British have gotten along very well in a democracy, thank you, with an unwritten constitution. But that doesn't mean that their constitution is a less effective limit on the activities of the government. And of course, the crucial point here is that state governments are very, very different governments from the national government. As Senator Lundberg alluded to, the U.S. government is a government of delegated powers. It has listed powers in the document, primarily in Article 1, Section 10. And as the Republicans in Washington sought to demonstrate this last session, where they asked for any bill that was introduced, the proponent had to state the portion of the Constitution that gave them the power to engage in this action. In order for the federal government to act, it must point to some power in the Constitution that allows it to do that. State governments are quite different. As a result of the 10th Amendment, which reserves powers to the state, with certain exceptions, generally state governments can make any law reasonably related to protecting the health, safety, morals, or general welfare of the people. If you read the Colorado Constitution, there are no listed powers of the legislature. They have generally plenary powers to make any law reasonably related to those functions. As a result, state governments are much more powerful in theory than the national government. Given that, the Constitution has to be suited to those powers. And in fact, most of the length of state constitutions simply are directives as to how the legislature and the government must carry out those broad powers or limits on the exercise of those powers. And that's where the initiative process as part of the Constitution comes in. Unlike, at the national level, which of course is a system of checks and balances, you need a broader check on the broader powers of the state government. And initiatives, constitutional initiatives, specifically serve as that check on the government. Why can't statutory initiatives do that? Because in order to be a check, it must be more difficult for it to change. If the legislature can overturn at any time as it can with the statute, then it's really not a check. Just as the courts check on the government through the power of judicial review should take extraordinary means to overturn, just as the governor's check through the veto should take extraordinary means, the people's check and through the initiative process must be lodged in the Constitution as a real restraint. And of course, as Elena will elaborate, there have been a number of instances where the people have tried to use statutes that the legislature just overturns them. So you want to keep in mind that you're talking about different systems of government, and you need a different constitution and get different powers retained by the people to act as a check. I'd like to close real quickly by alluding to something that Joe Trippi said about the consideration that the legislature has of the people and what they think of it. And this is what I was telling Senator Lundberg about when we were talking before we came in. If you ever want to know what legislators think of the people, go down to the state capitol and look for a bathroom. There are bathrooms all over that building. There are bathrooms all over that building, but they don't have any label on them. There is only one bathroom that is down in the basement, okay? I will tell you, as this history of this country demonstrates, what you think of people is determined by who you're willing to share a bathroom with. And the legislature is telling you what they think of you and where they will assign the bathroom.
Fantastic comments by one and all, and now we have a chance to open it up to questions from the audience. No, you're good.
We're going to have a roving mic so we can record the questions.
We're going to about 7 o'clock, so we'll try to get as many questions as possible.
Mel Elgenberg, Fort Collins, previously Denver. The legislature has once again dropped the ball on congressional redistricting, and the courts Cochran-Mander the congressional redistricting once again. Would it be possible with an initiated referendum to overturn that, actually have congressional redistricting in the interest of we the people?
Actually, let me cover one particular on that, Mel, and that is the timing wouldn't allow it. Not for the next election, which is when that redistricting is supposed to be there. Now, if you recall, 10 years ago, the legislature did come back and do redistricting after that first election cycle, and the courts threw it out on some pretty absurd charges that they were the legislature. I'm not sure you could move the initiative process through that for another reason, and that is the Constitution actually states the General Assembly shall redistrict. So it would be a far stretch to put that on the initiative process. Intriguing, but man, I tried to live through redistricting down at the Capitol. I'm not sure what we would do with 5 million of us.
One thing I'll say historically real quick is that the initiative process in other states has been used extensively to set up redistricting commissions and how redistricting operates. The actual act of redistricting, I don't know has ever been done through the initiative process, but the actual mechanism in which redistricting takes place has been done extensively through the initiative process.
Here in Colorado, in the early 1970s, there was an initiative, a constitutional amendment that was successful that removed legislative reapportionment or redistricting from the legislature and put it in the hands of an independent commission. So there have been talks about taking the congressional redistricting out and giving it to that commission as well. Now, what I don't know, just to follow up on Senator Lundberg's point, since if they had passed a bill, I don't remember looking at the draft if there was a safety clause, like if you could use the referendum process to try to overturn them. But since that didn't happen, it rarely does, I don't know. It's an interesting legal question.
Doug Anderson, Lakewood. Paul laid out a number of examples where the process has been under attack. How can we change that dynamic of backpedaling and fighting to keep what exists? What can we do to move things forward in the other direction, perhaps leave those who don't like the initiative process for once backpedaling?
One thing that should be done, I believe, is to, and it was spoken of up here, is to make initiatives for statutory changes easier. I believe that you would find, as a matter of fact, my wheels have been kind of turning while I'm up here thinking, what if that make an interesting measure next year? Because that would require a little more, well, that would empower the people that much more thoroughly. Where I've drawn the line is, because there have been attempts to pull the percentage down, but at the same token, by the same measure, it makes the constitutional changes more difficult. And there's where it draws the line for me. So that could be done.
One thing I'll add is that it's interesting, look at the state of Mississippi, you know, their initiative law there says you can use the initiative process for everything except to make the initiative process easier, basically. It's funny, but I kind of would like to see similar, one thing you could do, theoretically, is maybe pass legislation that says the legislature can't enact any changes or reforms to the initiative process until it goes to the vote of the people or something like that. I mean, I'd love to see personally some limitations on that, because even if in Colorado you design a system that encourages people to do more statutes, which is what we're hopeful for we have in Missouri with our Voter Protection Act. As we've seen as an organization, the legislature likes to overturn citizens' initiatives for statutory measures all the time. And so, in conjunction with making it easier to use the statutory process, I would encourage some type of limitation or hurdle that the legislature has to meet before they can overturn a citizen initiative, a statutory measure.
I'd just like to add to that in Colorado, where the process of amending the Constitution and passing a statutory initiative are the same, you always get the chimera, the smoke screen, that, oh, the problem is amending the Constitution, people ought to use the statutory route rather. And yet, every time you go to the legislature and say, yeah, well, okay, then make the statutory process easier, or you say, build in protections for statutory initiatives, that seems to go away. And that's where you get to the underlying what's going on, which is they don't want the people messing with legislative action. And the only way you can go on the offensive against that is make your views known directly in as many ways as you can. Letters to the editor, talk to people, use your organizational groups, but put the pressure on your legislators and let them know, because it's coming back next time. I guarantee you it's coming into the 2012 legislative session, and the goal is to get it on the ballot again in 12. It's, got more lives than Freddy Krueger.
And yeah, just to add on what Thad was saying, I think part of the challenge is that legislators feel like this isn't an issue that they'll take heed for. Some of them recognize that people aren't with them, but they assume that they're not going to hear from their constituents on this, so it's not hard to follow leadership, it's not hard to follow the very powerful interests of the Capitol. If you look at the groups who are supporting the referred measure this year, I mean, they really are the most powerful groups on both sides of the aisle at the Capitol. And if you belong to any of those organizations as a member, they need to hear from you that they're not representing your interests. And your legislators need to know that this isn't a pain-free vote if they choose to go against their constituents. Because right now they really do feel that what happens in the Gold Dome is a vacuum and they're not going to take heed for it outside that building.
Hi, I'm Lisa Solly, and I came into this process completely innocently about a year ago, and now know more about it than I ever dreamed I would or wanted to know, and most of it isn't very pretty. So my question for you is, this is a citizen's right. This is something that we should be passionate about, not as lawyers and professors and proponents of organizations, but as citizens. How do we turn around the public perception on this so that the public begins to say, you're right, this is our right, and stops buying the gibberish that's coming out of the opposition groups? So I'm just looking for sort of strategic ideas on how to turn public perception.
You know, one thing I'll say is that, you know, the initiative process isn't exactly a sexy process. And one thing that I've been working with the initiative and referendum institute, you know, it's interesting that I've tried for years to raise money on the issue or educate people about the process. But I think it boils down to, one thing that's interesting, in every single state where the initiative process exists, there's overwhelming support for it. I mean, we just did a poll in Missouri, Missouri, I don't know where you're from, and you know, showed that, you know, close to 72–75% support for the initiative process. The problem you get into from a very practical standpoint is when you start talking about the minutia of whether to ban paper signature or whether to put in geographic distribution requirements or whether or not to, you know, whether or not they should wear badges, so forth and so on. You know, that's when you kind of lose the citizens, you know, and when you're trying to get them motivated to fight against that type of minutia, it is a very difficult thing. I mean, one thing we're going to do as an organization, you know, we are, you know, one thing that we're going to start doing is trying to just, it's important for people to understand why these changes are bad. I mean, for people who have not done an initiative campaign, they don't understand why changing from a paper signature ban to, you know, paper signature ban to having to pay by the hour, they don't understand the actual impact it has on the process. And so I think the one thing from a very practical standpoint we have to do is that working through groups like the Independence Institute, working through the Humane Society, working through Citizens in Charge, or Common Cause, we need to start educating people about why this does matter, you know, why this makes a difference. And so therefore, once the voter understands that these fundamental changes will have a negative impact, then we can build on that.
I would just add, I think the other piece is reminding people how it's been useful in the past. I mean, certainly among progressive voters, I think there's a sense, you know, in recent years, in part because there's been a lot of money spent to get them into this place, that the process is bad and it's only used to, you know, do bad things in the state of Colorado. But when you talk to them and you remind them that it wasn't that long ago that the renewable energy standard passed through the initiative process, or an increase in minimum wage, or campaign finance reform, you know, just a few of the issues that progressive voters seem to have an affinity for, were on the right. You're reminded that it's only because of the initiative process that they got tapered through. That sort of dialogue reminds people it's not just an academic issue, it really impacts the issues that they care about that don't do otherwise.
The other thing that's always interesting to me is sort of the emperor has no closed tone of the arguments for the changes. I mean, again, I can't remember whether it was Joe who was talking about the fact that people initially, common sense, are opposed to it. And that's simply not true. I mean, people favor the initiative process, or the legislature will say, oh, it's captured by special interests. And they say that as a self-evident truth, and that the legislature is somehow better. And I always go to legislators and just say, gee, Representative, how many lobbyists did you speak to this year? You know, so it's sort of breaking through those mythical statements that get through it. I don't know how you.
I would add this final point. You've heard a lot of discussion on sort of the practical efficacy of it, but to me, it's the principled matter of without the initiative process, much of our freedoms and our liberties, I believe, would be jeopardized, because it goes right back to why in the world was the Constitution and the revolution that brought that about, why did that occur? It did because of the autocratic rule of the King of England and the British Parliament. And the initiative process puts the power back in the hands of the people, which was the whole point of that revolution. I try to bring people back to that point again and again and again, because I try to bring myself back to those principles again and again and again as I see all of the bills before me, and I have to ask myself, is this in line with our God-given freedoms of life, liberty, pursuit of happiness? And that's just the beginning of this.
My name's Albie Hurst, and I've been doing petitions in the street, or running petitions in the street for about 14 years. I have a suggestion, first off, if we're going to consider statutory amendments, changes, initiatives, why don't we keep it with the people? In other words, if there's a 3-year period where then the legislature can overturn that, then have them refer it back to the people with the changes that they want to see, and really put them in a position where they have to explain why they feel that that statute is not, beneficial.
One thing I'll say is that in our debate, and probably with Prop B, or Public Mill issue in Missouri, we proposed an amendment that said, why don't you just put it back to the people? If you really think it's so heinous or so bad, why don't you make your changes and put it back to the people for a vote? And the legislature said no. And the reality is because they know they would lose. And so that's what typically happens, is that they want to control, they want to maintain the power. They know that they're at odds with the citizenry, so they want to be able to do what they can do. That's one reason, in our initiative in Missouri that says that it's 3/4 vote of the houses, or they can put it back to the vote of the people. It's going to be interesting to see how many issues they actually put back to the vote of the people.
My name is Dan Lynch from Lakewood. I'm not going to do this justice, but all of this brings back to mind the famous quote from Bill Buckley, where he said he'd rather see the first 500 names from the Brooklyn phone book than some of the people in Congress.
My name is Vicki Marble, and I have a clarification and then a question for Dr. Texta. And I would like to, was it true that you said that the UK has gotten along well without a written constitution? My question is, how can that be when they have, gone into such a socialist state and now on the brink of Sharia law? Sharia law. They have many, many districts within the UK which are only Sharia law, and I just can't understand how you think they've done that.
Well, all I'd say in response to that is that among all of the measures of democratic government around the world, that British government ranks among the highest. And that if you look at violations of civil rights and civil liberties on the part of citizens, that although Great Britain doesn't have the greatest record in the world, it is probably no worse overall than other liberal democracies in the world.
Hi, Doug Kimmel, Red Colorado. Back in 1996 and again in 2006, Dennis Polhill and I both put before the Colorado public the Petition Rights Amendment, which we feel took care of a lot of these problems, but the public was inundated with millions of dollars worth of contrary publicity, and it ultimately lost. One of the things that we had in there was that we pegged the 5% signature requirement for constitutional initiatives, but allowed the state legislature to choose a lower percentage for initiated statutes. Then at the very end, we authorized the legislature to put on the ballot any changes they wanted to make to a citizen-passed statutory initiative. But taking off from that, Dennis Polhill, he was around here somewhere, did an extensive study of the 46 or so constitutional changes that have been done by initiative over the past 100 years, and discovered that of those 46, only about 10 or 12 could possibly have been done as a statutory initiative. So the biggest question in my mind is, where's the beef? And I'm not referring to the big initiatives either.
Well, two things I'll say number one is, there are certain issues that you have to use to go the constitutional route. Because, like we found out with term limits, statutorily you can't impose term limits, and you have to do it constitutionally. So there are certain places that if you're changing something in the Constitution, you have to do the constitutional initiative route. The other thing I'll say, picking up on what Doug said, is that initiatives very rarely pass. The percentage of passage is very, very low. And that's one of those urban legends out there. And that is because, voters are very cautious, contrary to what a lot of people think. Voters are very cautious. When they're uncertain about something, they will vote no. And that's why you can do a very complicated measure, or, we as an organization, we do extensive polling and so forth and so on, and try to limit what we put in things. Because an uncertain voter votes no, and there's this misnomer sometimes. We say, well, they voted no, so therefore they didn't want X, Y, and Z. Well, no, that's not true. They voted no because they were just uncertain about what that measure would do. And I think that's a critical clarification.
This will be the last question. I'd like to suggest that an answer to Mr. Anderson's question on how do we get off the defensive, and maybe Ms. Sully's question on how do we turn citizens' views around on this, would be that the best defense is a good offense. And the two best things that I've seen in the initiative world are Utah's attempt to have internet signatures to make it easier to get initiatives on the ballot, and Oregon's successful project to have what they call citizen initiative review, so that voters get the same kind of information on initiatives that legislators get on bills. And I guess actually there's a third way to go on the offensive, and that's to promote national ballot initiatives, and I guess the best one out there is Senator Mike Lavell's. I'd like to hear the panel's thoughts on this.
Let me add one thing to, I think, your center, or kind of in the middle of your discussion there. You said information be afforded to the voter about the initiatives. We do have the Blue Book, which is fraught with all sorts of political
propaganda.
Yeah, and you're right. You're right. It's when you get to the end of the day, it's very hard to sort out just where the facts are, and it's inevitable. It's honestly inevitable that it's going to work that way. There are so many political considerations and space and cost considerations and time, and who are you going to go to for which side of the debate on that. I honestly believe that what we're doing right here is a very positive step forward as well. And it's like everything else. It's not this big glitzy, do something that now everybody understands so much, step-by-step process, and this is one of those steps.
Just in this conversation, again, it's the same kind of mythological comparison with the best of all possible legislatures, against the average initiative. It's assuming, of course, that legislators are making their decisions based on unbiased information that they're getting from lobbyists, or that they're really well informed. Now, I know Senator Lundberg would never do this, but if you've been down visiting the legislature, you'll see one person tugging on the person next to them and saying, which way are we going on this one? How few people know what they're voting on most of the issues on which they are voting. And yet, the initiative process is always compared to the platonic, perfect legislature composed of all-knowing Solons who are making impartial decisions. And if you break through that myth, the people do a pretty good job of making decisions. They don't pass most of them, as we've just heard. People get a sense, and when in doubt, they vote no. And so it is a tough hurdle to get through. And we shouldn't try to say we have to create the perfect institution so that we can measure up to the perfect legislature, because we're dealing with everything, anything but perfect legislatures out there.
Well, yeah, I guess just to echo Thad's point, yeah, if the perfect were the only possibility, we wouldn't have very many mechanisms for doing much as a society. Two things. One, on the Blue Book, I would agree with Senator Lundberg. Perhaps we have different takes on when it has fallen apart, but the Blue Book process is wrought with problems. And we actually sued, and I think it was 2004, because during that final step where the legislature takes the research that staff has compiled, they get to kind of do a rewrite at the last minute, and we thought that wasn't quite accurate. So I'd agree it's an area where there's a lot of opportunity for reform, and the Oregon model is certainly a good, interesting one. The other thing, just on signatures, I don't know how many of you have seen this. The initiative that's currently being circulated right now by Senator Heath, it's a tax increase. For the first time, you can download your petition off the internet and print it out at home. So instead of having to go and pick up a petition from someone with a campaign or have one mailed to you, you can just click, affirm that you're a citizen, go through some basic training, and then go ahead and print and start gathering signatures. So not a perfect solution, but begins to move the process of gathering signatures out so that people throughout the state can do it, and you don't need to be able to print enough signatures, enough petitions to get all your signatures in order to be able to provide the solution. So it'll be interesting to see how that plays out.
You know, one thing I want to add real quick about that is, you know, as far as internet signature gathering, when I ran the Institute, and even now with the Humane Society, I mean, we're trying to work more closely with organizations to try to bring internet signature gathering. But we had a conversation with the Secretary of State of Washington State, because we're doing an initiative there, and said, hey, you know, is there a way we can actually just download petition signatures in Washington State like they allow in Oregon and other states? But in Washington State, they require the signature petition sheet either be 11 by 17 or 17 by 22. And they refused to make it a size that you can actually download. They said, oh, well, you know, we might consider it if the average person will have 11 by 17 or 17 by 22 paper at the house. We can't even buy that at Staples, okay? So the problem is, the reality is, the bottom line is, as much as I hate to say it, you know, there are a lot of great reforms and changes that can come to the initiative process to make it more usable to the average citizen and to the average group. However, lawmakers, as we all heard, they don't want to make it easier. They refuse to make it easier. And we as an organization have reached out to lawmakers to try to bring about some fundamental change. But for whatever reason, well, you know why, lawmakers will not even entertain anything like allowing signature gathering over the internet.
With that, I want to make actually one more announcement before we close this program. It is Colorado, and the legislature is now out of session, so it must be time to award another Lilburn Award to a Coloradoan who has helped stop some of the worst attacks on the process. And I want to take this time to announce that Thad Texa is the winner of the May like we're in Washington. We long for the day that Colorado citizens don't have a leg up in this Lilburn Award process. So, anyway, I want to thank everybody for being a part of this. I want to thank this panel, who I think deserves another round of applause.